hear me? Hello, can we all hear me?
Yes, we can.
All right, good evening.
Yes,
Thank
sir.
you all.
Good evening, sir.
Yes, good evening. Thank you all for joining. So welcome to class. We are officially in the third week of the JIIPCC Mentorship and Internship program, and I especially want to welcome everyone that is currently on this call. So just like we have been doing, we will just introduce, I would just like to introduce this session, right? And then introduce some of the mentors that we're expecting in today's class. And then we'll kick off from there. Firstly, my name is Dennis Williams, and I will be helping moderate this particular session. So just to give us a breakdown of what we are going to be doing, we're going to be introducing mentors. We're going to be taking presentations from both Group 1 and Group 2. So just get ready for the group presenters. Please get ready to make your presentation. You have 15 minutes each for your presentation. And after we're done with your presentation, we would head back to the mentors to get their feedback and their discourse for today. And after that, we'll take questions and then pictures and call it a day. Right, so that is how we'll be flying today. So not to waste any of our times, I'll just quickly be introducing the mentors that we'll be expecting in today's session. So firstly, he needs no further introduction than, we're already very familiar with Mr. Nyacham Nawan. He would be on the call with us today, right? And I expect that we would have a great session with him. Thank you so much, sir, for everything that you do for us, right? Secondly, we're expecting to have Mr. Tohid Amuda. Right, Mr. Tohid Amuda would most likely be our second mentor for today. Thirdly, we're expecting in class once again Mr. Idris Mohammed, and then also Mr. Isaac. Mr. Isaac, I can see Mr. Isaac is already on the call. Thank you so much, sir, for joining. We are happy to have you in today's session. I can see Mrs. Sewa Ese. Sorry, Ma, if I'm still struggling to pronounce your name rightly. Thank you so much, Ma, for joining. I can also see you are on the call. We are happy to have you again in class. Thirdly, we are expecting to have Mr. Babajide Adams. Also, we are also expecting to have in today's class Miss Amina Ezekiel. Okay, and then we are also expecting to have in today's session Mrs. Baratu Dangana. And then last but not least, we would be having Miss Omotayo Blessing. So those will be our mentors for today's session. So please let us sit back and just have a great time in class, right? So like I said, we would be we will be taking presentations first from the mentees, right? So we'll be having you present first and foremost before we take the discourse from the mentors. So please, if we can, group presenters for group 1 and group 2, kindly share your slides and then start your presentation. Can we have the group presenter for group 1 in class today?
Yeah, good evening. Has the slides been shared to you? Because I can't share from my phone. So you'd have to do that for me.
All right, so give me a minute. I will be bringing that up right soon. Sorry, just a moment. I'm about to draw it up. Uh, Is my screen showing? Okay, can you see my screen?
Yes, sir, we can.
Yes, I can. Um,
Goodness, are you sure? Hello, goodness, are you with us? Sorry, we can't really hear you.
okay, I was asking if I should start or not. So I was waiting for like a
Oh,
response.
please, please, go ahead.
Okay. Good evening, everybody. My name is Elezu Mesoma Goodness, and I'll be presenting for Group One. So we're given a few subtopics to talk on. The first, which is arbitration and career opportunities. I'm sure we've already known the meaning of arbitration and all from our previous classes. So straight to the career opportunities in arbitration. From one, there are a list of roles that are listed here for an arbitrator, and this list of roles we can all agree are things that are very much needed in companies today, in commercial sectors, corporate sectors, the government, international bodies, and so on and so forth. So this shows that an arbitrator is needed in every single part of the economy, which means you can be employed as an arbitrator in any firm per se. Yes, and some people might argue that lawyers can per se fill up that position of an arbitrator in a sector. But I would like to probably disagree with that. Why? Because I feel like from a little experience from internship and negotiations, I've seen that some lawyers do not know how to separate the courtroom from an arbitration proceeding, and they sometimes tend to take things out of proportion and all. So that means an arbitrator is quite needed in that area. Another career opportunity you can have is in academia, which means you can teach area ADR, share your knowledge on the field and earn from it. Another part is consultancy. From consultancy, it means maybe companies who do not want to hire an in-house arbitrator also can consult one to give them. I don't know how legal that is, but okay. The next subtopic we have is arbitrability of disputes. This means disputes that can be resolved through arbitration or through ADR. One, we can have private matters, commercial matters, contractual matters, employment matter. That's from wrongful terminations, um, things that lease agreements, Lagos landlords and their problems, things like that can be resolved through arbitration. These are disputes that can be resolved through arbitration. Then examples of non-arbitrable matters. We can see matters that are out of the rights of the two parties. We can make an example of child custody matters. Those kind of matters, we can say this now. It's is more than just the right of the mother and the father, which are parties to the arbitration. Another person's right is being in question, a child, and which is a child. So experts should be involved in this kind of proceedings and all, which is why it is better to be in court. Someone can say, okay, this same expert can also be around during the arbitration proceedings and give their expert advice in that place. But I would say in ADR, the parties still have their autonomy, which means they can still decide to not go with the expert's advice, which is why I think the court should be more in place for things like child custody and things like that, so they can enforce both the law and expert advice and put those in place for that kind of matter. Another disputes that cannot be addressed for in ADR can have issues that involve the state, like criminal matters and all people things that are in between the state and individuals, and not just between individual and individual. The state is involved. It cannot be resolved through arbitration. Another matter that can be resolved through arbitration is things that involve state functions. That's things like taxation, electoral matters, things like that. You can't resolve them through arbitration. They can be resolved under ADR. You have to go to the court. And then also things that are in opposition to public interest. They can be resolved under arbitration. The next subtopic we have is arbitration clause and its significance. Arbitration clause can be referred to an arbitral agreement put in the original agreement of that has to be referred to ADR for dispute resolutions. Some people might say, okay, then what's the difference between an arbitral agreement and an arbitration clause? I'll say the difference is an arbitral agreement is the agreement between both parties on how things should be done and that they would refer to ADR. But where arbitration clause comes in is that arbitral agreement is now infused into the the original agreement between the parties. That is, it, as once it is infused into that original agreement, then it's an arbitration clause. But if it is a distinct document, that means a different document from the original agreement, then we can call that an arbitral agreement. Then going to the significance of arbitration clause, we have certainty. Certainty in the sense that parties already know what will happen if there is a dispute, how they are going to resolve that dispute. From that, we can now bring up that it saves time and cost. Because parties already know how things will be, it's going to save time in maybe filing a case to court. We all know how rigorous the filing filing matters can be. So it saves time for that because they already know what it's going to be, and because there is already a certain there are already like things already laid out for this arbitration clause. It also helps with time, yeah, because everything has been put in place beforehand, so everything is known. There is no need to start going to look for a seat of arbitration to where we're going to do the arbitration. There's no need to start thinking of which jurisdiction laws are we using to handle on this matter, what laws are going to be put in place and all that, because it has already saved time from it. The next subtopic we have is the revocation of agreement arbitration agreement and clause. Um, Ways that an arbitration clause and arbitral agreement can be revoked. We have consent of both parties. If both parties consent that okay, oh, we want to revoke this arbitral agreement, or we want to modify it and change it to something else, it can be revoked. But one thing that cannot happen is that a unilateral wish to just you want to just suddenly want to go to court and file your matter, that cannot take place. The only time where it can be allowed is when the other party waives his rights. And how can he waive his rights to this agreement is by not maybe negligently just following through with the court matter, not countering it. If you don't counter, it simply means it's an implied agreement that you've now agreed to it. So that's the first revocation, the ways of revocation. Another one is if the arbitral agreement is invalid. Ways an arbitral agreement can be invalid is through fraud, misrepresentation, coercion, duress. And for fraud, we can see case laws of Union Bank versus Ajibule. For misrepresentation, we have Okoli versus Maricap Finance. And for duress and coercion, we have a case of Afribank versus Alade. In that case, the court was magnanimous enough to say even economic pressure, financial pressure on a party for him to agree to that agreement can also be voidable, can also make that arbitral agreement voidable, which is quite unanimous for that kind of thing. Another thing is minors. If minors are involved in that agreement, it can't hold, it will be revoked or rescinded. We can find laws on that. You can find it on section 29, subsection 1 of the constitution, and also the Infant Relief Act of 1874, which says an infant cannot go into any agreement or contract unless it is for necessities. And I really don't think arbitration is a necessity for a child. Another one is when it goes against public policy, it can be revoked. And then when a court gives an order, if the court gives an order to um revoke that agreement, it will be revoked. And when can courts give orders? Courts can give orders when the arbitral agreement is ambiguous, is vague. There is no specifics given to it. When there are no specifics given to it, the court can waive it out and waive the agreement out. And then another way it can be revoked is when it is a um, non-arbitrable dispute. If it's a non-arbitrable dispute, of course, it can't hold. The next subtopic we have is award and its important aspects. Award. Award is a final decision issued by arbitrators, an arbitrator or arbitrators tribunal at the end of an arbitral proceeding. We have types of awards. We have the final award, interim award, partial award, and the consent award. The final award is, as it said, the final award is the with the final decision of either the arbitrator or a tribunal. That's the final award. The interim award is like a temporary award, and most times it's given to prevent the breach on one of the parties' rights. If maybe if you don't give this particular order, one of the parties' rights will be infringed on or breached or encroached upon, then you give an interim award. Then we have the partial award. Partial award is when, let me say, there are four issues of determination in the arbitral proceeding, and there have been two of those issues have been given awards. Then we can say those two is like a partial award, but a partial award is still binding because it is not the final, does not make it not binding. It is binding on those issues that the awards have been given on. Then we have the consent award. This is where the two parties they make a settlement on their disputes and decide to not give it to the appraiser that, okay, oh, we've already settled. Can this be, let this be our award, let this be our final decision, and it is arranged for them. Then we have the important aspects of awards. This is just the components of an award that an award must contain. We have the names of the parties, the names of the arbitrator, case reference, the jurisdiction. Jurisdiction is what if let's say one party is from Nigeria, the other party is from China, what jurisdiction, what laws are we going to use for this thing? Is it Nigerian laws or Chinese laws? Or where is this thing going to hold? Is it in Nigeria and China? And we also have the background of the case. The facts of the case must also be included in the award. The issues for determination must also be included in the award. The reasonings behind the awards, the reason why the arbitrator or tribunal gave the award must be stated there. The evidences they analyze, the laws, the arguments, that the actual decision, that's the final award, the final decision of the arbitrator or tribunal must be imputed in the um award, and then the date, the seat of arbitration, which is the place of arbitration where it's held, the signatures of the parties, and so on and so forth. Thank you.
All right. Thank you very much. Thank you very much, Ms. Omar, for your presentation. We appreciate the efforts um, to make the presentation and everything that you have shared in class. Well done to you and to your team for putting together your presentation. So please, we would like to have Group 2's presentation right now. If members of Group 2, if the presenter for Group 2 is ready, we are ready for you to. Please, you can go ahead and start your presentation. Okay, who is presenting for Group 2? Sorry, I didn't get you, sir. No, sir. Okay. So, all right. So before we take Group 2's presentation, Oh, all right. So before we take group two's presentation, can we just quickly turn on our videos for our pictures quickly? Right. And while we are doing that, let the presenter for group two please kindly get ready so that we don't waste time waiting. Right. So thank you, everyone. Thank you, Mr. Isaac. All right. So we are done with that. We are done with that. We are done with the pictures. Group presenter, please over back to you. Please, you can continue with your
But my
presentation.
my video was blank. Were you able to capture me?
Yes, sir, we were. All right, Mr. Paul, if I'm not mistaken. All right, so I can see you're the one sharing your screen. Please go ahead and make your start your presentation. Sorry, can we all hear Paul, or is it just me that can't hear him?
We can't hear you.
Okay, Mr. Paul, we can't hear you. Maybe you should log out and log in again. Sorry, we can't hear you. Your speaker seems to be. I can see your mic is unmuted, but no audio is coming out from your mic. Hello, Paul, can you hear us?
Yes, I don't know if it's audible now.
Yes, we can hear you.
Yeah, sorry, I was having issue with my system, so that's why I'm unable to. That's why you're unable to hear me. I don't know if they could help me share the slide because I'm connecting with my phone now. I'm still waiting for the slide, please.
Hello, can we hear you?
Yes, I don't know if I'm audible.
Please, Mr. Paul,
Go on, sir.
please can you please go ahead and start your presentation? Okay, if Paul is not able to make presentation,
I think Paul is online. Paul is saying that if you can share the slides for him.
So please for the delays. I guess I'm audible now.
hello everyone. Sorry, I'm very, very sorry. I sincerely apologize for the background, for the sorry, the little network interruption. My network went really, really bad. Um, my network went really, really bad. So I don't know if we have someone who can stand in for the group presenter for group 2, right? So that we don't waste time with trying to wait for your presentation. We really sincerely want to take group 2's presentation. If we have anyone that can stand in on behalf of group 2, would want to take the presentation. Yes,
He's
sir.
asking whether you, yeah, he's asking whether you can share the slide for him.
Oh, okay. I'll try and do that. Sir. Sorry. My network was giving me issues, so I wasn't hearing.
Can you share the slide?
I will do that now, sir.
Okay.
All right. Hello, can we see my screen?
Yes, we can.
All right. So sorry once again. I sincerely apologize for the silence. Please, we can go ahead and start our presentation group soon.
All right, good evening, everyone. My name is Paul Michael. I am the presenter for Group 2. So our topic for today is arbitration career opportunities. And there are several subtopics we'll be looking at. The first one is arbitral awards and clauses. So before then, what's arbitration? Arbitration is a private process when parties in a dispute appoint a neutral arbitrator who gives a binding decision, which is otherwise called an award. So it's an alternative way to court litigation. Now, what's arbitral clause? Arbitral clause is a section in the contract where parties they agree to settle disputes through arbitration instead of resorting to court. And then what arbitration awards? Arbitration awards is that decision of the arbitrator or that of the tribunal. On our third slide, we'll be looking at the relevance of arbitration clauses. So arbitration clauses are relevant because they resolve disputes fastly and as well privately, which is outside the court system, which is
Being known with the public nature, that is, individuals could, anyone at all could be able to visit the court for hearings. So the arbitration makes it easier for your matters to be resolved privately. They are also valuable in high value or international contract as well, and they promote for efficiency. Then on the fifth slide, we have the sample draft of an arbitration clause. So this slide is a typical arbitration clause. It identifies the law, the number of arbitrators, the seat of arbitration, and as well it states that the award is final and as well binding. Then on the next slide, we're having the key features of an arbitral award. So arbitral award must be that decision by the arbitrator or the tribunal, it must be written and signed, as well it must be reasoned. That is, there must be a particular reason for it. In litigation, we call that a ratio decidendi, and as well the date and the time must as well be stipulated, and then the finality as well. It is also final, that is binding on both parties, and as well it is enforceable. So these are the features of arbitration award. Then on the next slide, we have a draft of an arbitral award. So it's just a sample of an award format. It starts with an introduction. It sets out the disputes, then it lists the findings and the tribunal's decision. So this particular example is awarding damages to the claimant, that of 500,000 naira. So the next slide, we're having the ethics in arbitration. So generally, arbitration relies on ethics, that is that of neutrality, confidentiality, and fairness by both arbitrators and as well the counsel. This was actually what makes the arbitration work. Then we have on the next slide, we have the differences between the place, the seat, and then the rules of arbitration. So the place of arbitration is the physical location of hearings and meetings that is being chosen for the convenience. Then the seat of the arbitration is the legal jurisdiction governing the arbitration. So it decides the procedural law and issues like appointment or removal of arbitrators and challenges to awards. Then the rules of arbitration are the procedural framework. For example, the UN CITRA rules or institutional rules like ICC, or the ones the parties set by themselves. Then on the next slide, we have how to challenge an arbitral award. So awards can be challenged on limited grounds, such as invalid arbitration agreement, lack of jurisdiction, or procedural irregularities, like improper tribunal composition. Other grounds as well could be that of fair hearing. Where there is no fair hearing, you could be able to challenge that, or where there is an issue of fraud, or where there is corruption or misconduct by the tribunal. For example, if there is undisclosed conflict of interest or bribery between one of the parties to the dispute with the arbitrator. Then on the next slide, we have the conditions. We have the enforcement of arbitral awards. So under Nigeria's Arbitration and Mediation Act, an award is recognized as binding and may, on application, be as well enforced by court once the original or certified award and arbitration agreement are produced. So when it, as regards foreign awards, the New York Convention applies if the other country is a signatory. So this makes Nigeria awards enforceable abroad as well, and vice versa. So Section 60 makes the provision. Then in conclusion, Nigeria's arbitration framework balances finality and fairness. So arbitration is now vital in commercial dispute resolution, and as well it offers career paths as arbitrators, counsel, institutional staffs, legal consultants, and the likes. Thanks a lot.
All right, thank you very much, Paul, for making presentation on behalf of your group. We once again apologize for the issues that we had trying to set this up. Apologies to both mentees and mentors. So seeing that we have taken presentations from both groups, we'll be heading back to our mentors to help dissect today's topic. We are talking arbitration and the career opportunities in arbitration. So I would like to hand over to Mr. Nyacham. Hello, sir, if you're with us. Over to you, sir. Mr. Nachan, can you hear us, sir? Or can you hear me?
Yeah, thank you very much. All right. So thank you very much for the opportunity, for the time. I want to first start by appreciating all the mentees for putting this work together. Uh, you are greatly appreciated. So before we go into the the activities of the day, the mentors are going to make their contributions and where necessary. But I expect that the mentees should be able to ask relevant questions based on what they have on ground. That will go a long way to help uh, identify some issues or matters and then address them, accordingly. So let me start by calling Mr. Adams. If Mr. Adams, sir, if you are around,
Good evening,
do you
everyone.
have any input? Please go ahead and make your input while the mentees prepare to ask questions. That will make us cover a lot and just making contributions. All right, thank you.
All right. Good evening, everyone. So I've seen the works of the mentees, and I want to first of all appreciate all the mentees for a good job they have put together this evening. I'd like to go through the habitual clause and awards first. And so when we talk about habitual clause, now we are saying before you can be submitted to arbitration, of course there'll be an agreement between parties. In the said agreement, there will be an arbitral clause. And in the said arbitral clause, be provision for this of the arbitration. The Can I go on? There will be provision for the place of arbitration, the seats of arbitration, the number of arbitrators to be appointed, in some cases, the laws that will be applicable to the arbitral proceedings. So it will be much easier when the arbitrators are appointed to be able to work with this agreement of parties. It makes arbitration much easier for parties and even the arbitrator when all these things are put in place. For example, the appointing institution or whether it will be between parties. So all those things will be constituted in the arbitration, in the arbitral clauses, in the arbitral clause. So by the time the arbitration is to commence, these are some of the things that will be looked at because it has been agreed by parties, and so it will save the parties a lot of headache, either to appoint one or two arbitrators. But thanks to the Arbitration and Mediation Act 20, the new one that has stated that in case parties do not agree on number of arbitrators, it will be one arbitrator that will be appointed, unlike the previous law and unlike the UNCITRAL convention. In the UNCITRAL, is still, if parties do not agree on the number of arbitrators, it is 3 arbitrators that will be appointed. And so all these things have to be stated in the arbitral clause to assist parties even before the arbitral proceedings commence. And so even also another thing we should look at is by the time parties are yet to appoint arbitrators, there's a provision in the HAMA that parties can still have an emergency arbitrator to look into 1 or 2 matters they might have even before the arbitration is constituted to and so that's where the arbitration clauses come in. Now for the award basically, if it's in the court, we call it judgment. If it's in arbitral proceedings, we call it arbitral award. And this is basically the findings of the arbitrators at the end of the day, looking at like has been stated in this presentation. I don't want to be going through everything. We'll have to look at the findings of the arbitral proceedings, the reason for their findings, and to be the award will then be given. And so in case parties are refuses or are yet to settle the fees of arbitrators, they can place lien on the said arbitral awards, and they might refuse to give the arbitral awards. They might refuse to read it until their fees are being paid. So that's some of the empowerment the AMA 2023 has given the arbitrators. So once their fees are fully paid, then the award will be read. Of course, it has to be in writing, and so all parties would then listen to what the award states. And so it is unlike mediation where the decision comes from parties. This is more adversarial in nature. And for the second presentation was basically looking at who cannot submit to arbitration. Of course, an infant cannot, someone that is not mentally capable cannot, and so I must say, by and large, that the presentations have been thought-provoking and well-researched by all the mentees on this call. I appreciate you all. Thank you very much. Well done.
Okay, thank you very much. Thank you very much, Mr. Babajide. Okay.
All right. All right. So thank you very much, Mr. Adams, for your contribution. Let me hand over to Mr. Isaac. And I would like him to first start with the important thing that has to do with arbitration, the arbitration agreements, arbitration clause, whether at the inception of an agreement, the parties decide that if a dispute arises, they will Mr. Isaac, this one that you're wearing glasses today, we're in trouble.
In fact, today, first of all, let me commend them for the research that they did. But the presenters, I'm not happy with them. It didn't present the work like they own the work. It's like somebody has done the work for you to go and read. So I'm not happy with them. They should be able to own the work and prepare as you prepare yourself to come into the field. The work is yours, so let us know that it's you. So group one and group two, well done, but I wasn't impressed with the presentation. Um, Going on with my comments, the structure of your presentation, I think maybe you can work more on it when it comes to, you are talking about arbitration, then careers in arbitration. So we must talk about what arbitration is. It doesn't matter whether the people you are presenting to know it before or not. So that one doesn't matter. You take the people as whether they know it or not. You must quote a definition. So a simple definition could have been the definition which has been provided by the AMA 2023. What does the AMA defines arbitration as? You can just use that one. Then you move on to the other. You can talk about characteristics of arbitration, the mode, the form, how arbitration characterizes, how it can be the initiation process or what makes a valid arbitration agreement and all that. Then you can talk about the other stuff like the careers and other things. So a few things that I wrote down. The clause, the first presenter was mentioned and trying to differentiate between clauses and arbitration agreement. We don't have, when we mention arbitration clause, it's the same as when you mention arbitration agreement. Normally we made reference to it as clauses because it may be one of the paragraph in a contract. So whether clauses or arbitration agreement, they are the same. So we don't have clauses and we have agreement. What maybe you were trying to do is that in arbitration there are pathways, whether or not the people have a prior agreement in their contracts or they don't have a prior agreement. So if they have a prior agreement, which is the arbitration agreement in their contract, yes, that is one. Or they don't have any prior agreement, but when there is a dispute or disagreement, they decide to go for arbitration. That one, they still need to sign an agreement. That is what we call submission agreement. So it means that you have a prior agreement, which is still arbitration agreement or arbitration clause, and you can still have an agreement after the dispute has arisen. So it means that the people have decided to submit themselves to arbitration. That is why I was talking about, if you have mentioned the characteristics, it makes it simple because it is party driven. One of the characteristics will tell you that arbitration processes are party driven. Parties decide that we want to send this matter to arbitration. We want to agree on the terms. Like the first mentor was mentioning about the number of arbitrators, where should be the seat. As your presentation, yes, you people were able to define the seats as the legal place and also the venue. The venue can be anywhere, but the seat, that is the governing law of the seat, is the one if you need to challenge maybe a decision that has been taken by the arbitral tribunal or the arbitrator, then the governing law within the country, or if they disagree on certain things, then the governing law supersede those things. So these are some of the things that you must bring to bear when you are doing such presentations so that it will be clear to all of us. Then the group one mentioned about hiring of arbitration, and she was like, I don't know whether this is legally or not. When it comes to the work of an arbitrator, whether you are doing it as a private consultancy or you are working with a firm, arbitrators do not appoint themselves, or organizations do not just engage them and give it to a party to use. There are processes. So the arbitration agreement can give how the arbitrator should be appointed. Like, for instance, each party will appoint one arbitrator, and the two appointed arbitrators will appoint a third arbitrator, so making it a three-member tribunal. Or they can decide that the parties will waive their rights and appoint settlement house to select an arbitrator for their approval, appoint the arbitrator for them. So settlement house can have a list of arbitrators come to the settlement house. The list can to them party from the last one. The party can try to bring their own ability and understand. A firm like say settlement house can working can also or necessarily use your arbitrators. So the center may be there and serve as only as a registry and help the parties to manage the process. So in arbitration, one key thing that most of left out is that there are two pathways whether the parties want to go for an ad hoc process, which means that the parties are using an institution to run for them. So themselves will select their people and manage their own process, whether they appoint people to manage the process for them. That is an ad hoc process made to govern such processes when it comes to international arbitration. If the parties are not using the institution, then such laws can govern those processes. Then parties can also decide to use institution like settlement house. To use the institution means that either you are going fully under their rules, like it happens in the court. If you decide to use a certain court, you go under the rules of that court. The same way when it comes to arbitration and you want to use an institution for your arbitration, means that you are going under their law. So if you mention that you are going to use their law, so you are going to use the law, the settlement house rules on arbitration, then you use it and run it. Then another thing that I didn't come out clearly was also we have domestic and also international arbitration. So when a company in Ghana versus a company in Ghana or government of Nigeria, if the person is in Ghana and the other company is in Nigeria, it becomes what cross-border, so it is international arbitration. And that is why arbitration comes in, because whose courts do we go? So the party arbitration and they expect a neutral institution to handle it. That is why you may see some of your arbitration processes with London going here, going that. That is how it is. So we have, if it is domestic, it means that a company within Nigeria against a company or individual in Nigeria against themselves. That is domestic, and it is being governed by the Nigerian Arbitration and Mediation Act. That is the domestic arbitration. And then, Group 2 also try to talk about relevance of arbitration. What you put there, I didn't see whether it was relevance. So please check that portion again if you are talking about relevance of why is even arbitration important. If you are talking about relevance, then you are talking about why arbitration. Why is arbitration important? So the relevance you put there, if you can check it again. Then seats. You mentioned seat, you mentioned location and all that, which were good. You're able to bring those things out. Then you talk about ethics, characteristics of arbitration, which I didn't come up. So we may talk about characteristics as party driven is based on consent. So parties must consent, whether it's a prior agreement or other agreement, the parties must consent. Then the two presentation, I didn't see the arbitration process. How does arbitration start? We can talk about the theoretical aspect, but when somebody has a clause, how does the person initiate the clause? So now it brings us to the first point again, whether it is ad hoc or it's an institution. If it is an ad hoc, then you go and look for the rule that the parties chose to use to initiate the process. If it is the uncitral rule, then you go and look at the article in that rule which says that you can initiate it on a certain way, on certain terms, how to issue the notification. So when you are doing uncitral rule talk about notification of arbitration. Then you must give notice of arbitration. You give notice of arbitration, then you must demand for arbitration. Then you if you go to ICC means that you must request for arbitration. If it is an institution like ICC, you must request for arbitration. So depending on the rules that you are using. So if you want to initiate the process, you must look at what rule have the parties agreed upon. If there are no rule, what does the governing law say? How you can initiate a process? Then you can have to also go and look at the AMA 2023. What does the AMA say about it? If you come to Ghana, section 6, that I think section 5, 6 talks about initiating arbitration process, and you can send it to if they have not mentioned specific institution and it is just generic. They said that they will go for arbitration. The law says that you can go to an individual, the institution, or the National ADR Center, which the Act establishes. Then you can go to that center or institution or the individual and initiate the process. But the moment you initiate the process, once an arbitrator is appointed, within 14 days, with 7-day notice, the arbitrator must conduct what we call arbitration management conference and discuss with the parties how they want issues to be determined, like when you go to do case management. Arbitration also, depending on the rules have happened or by between the parties and the arbitrators before to meet them and discuss the issues and agree on the terms of reference. Then the parties and the arbitrators will sign the terms of reference. Then the actual process will now begin, whether they will call for witnesses or they will use witness statement or all these things will be agreed upon. Then the hearing will start. The duration for hearing will be determined based on the timetable that the parties and the arbitrators will agree. They will do the hearing. After the hearing, there will be duration for the writing of the award. Then the award the parties will now receive the award. If you are doing ad, it goes straight to the parties, and that is the end. But when it becomes institutions like ICC, then it means that the arbitrators haven't, which has to review the award to know that it conforms to the ICC standard before it can be released to the parties. So these are different. So when you are choosing an institution, you must know what goes into that institution. If you are to know which kind of institution and what you must do at that level, then I was also I think I saw a few of them. I was also expecting to see some mention of specific sections of the AMA 2023 because once you are practicing in Nigeria, that is your Bible as an arbitrator, and you must understand the various provisions that the AMA has given you. And then I think that will be all for now. If there are questions, I'll come back later and answer them. Thank you so much. I think people were saying that they can't hear me. Is it? Am I audible, or people couldn't hear me? Lanchan, can you hear me?
We could hear you, sir.
Okay. So this is the if I have to say now. Thank you.
Yeah, your voice was clear anyway. Your voice was clear. Thank you very much, Mr. Isaac, for that wonderful contribution all the way from
Thank you.
Ghana. All right.
Greetings.
Um, let me come to the mentees. Please, I would like you to ask questions at this point so that we'll try and address as many as we can. Because arbitration is wide, and if we say we want to start going through some of the things, we may not live here today. So questions will actually give us a pointed direction as to, it will give us a pointed direction as to some of the things that the parties, the mentees may want to know in the course of this mentorship. So Dennis, please, mentees are free to ask questions and will be available to answer them.
All right. Thank you very much, Mr. Nyacham, and thank you to all our mentors who are on the call. Like Mr. Nyacham has said, we'll be taking questions to help guide the course of direction of our discourse today, right? So seeing that arbitration is kind of wild and we may not be able to cover everything today, but to kind of give perspective to, particular things that may be important for us to know in terms of our research and everything that we have done so far. Please, can we ask questions? If we would like to know anything about arbitration, you can go ahead and ask. So please, we are taking questions, live questions. You can send your questions into the chat box. Okay. I can see Ashimi, right? Sorry if I didn't pronounce your name very well. Please, you can go ahead and ask your question. Please, we are still taking questions. You can raise your hands.
All right, so thank you very much, sir. Good evening, everyone. My question is there a particular difference between arbitral proceeding and arbitral institution?
Okay. Just as the name implies, arbitral institutions are institutions that carry out arbitrations. For example, Settlement House Idiot Training Institute has a center that carries on arbitration. So these institutions, it could be private organizations or institutions or government regulated. You have Chamber of Commerce, in different states, both nationally and internationally. You have institutions. We have, for example, in Nigeria, we have Lagos Court of Arbitration. They are just ADR inclined. So those institutions or institutes usually have their own panel of neutrals. So those panel of neutrals, where there is a dispute, if it is a specialized dispute, for example, you have it. If it is a specialized dispute, you get panel of neutral. Let's say, for example, construction dispute or construction arbitration. You have parties who are specialized. You have panel of neutrals who are specialized, right, in construction disputes. So this different organization, if you go to their website, for example, under Settlement House Media Training Institute, you will see our list of panel of neutrals. Some of them that have been uploaded, you will see them. They possess expertise in different fields. So institutions are like organizations, arbitral institutions are like organizations that actually provide avenues where people can come and initiate and conduct their arbitration or arbitration proceedings. While arbitral proceedings, on the other hand, is actually that's when there is an arbitration and then you commence the arbitration and you start, you went through initiation of the arbitral proceedings, which is one of the things that you need to know. At the point after your okay, let me start from this point. Where there is a dispute or when parties are going into an agreement. Please, what's the name of the person who asked this question?
Yes, I am Ashimi Salban, sir.
Okay, Ashimi. So, when you want to go into a contract, let's say as lawyers, you want to go into a partnership, you form a partnership, and then one of the lawyers is not going to court, but is going to concentrate mainly on bringing clients to the office, while the other partners will prepare the processes, and then we have another partner who will be going to court to prosecute those matters. Now, when they want to form that partnership, they may decide that, okay, if there is a dispute, that's before they form the partnership. If there is a dispute, we want to resolve this dispute via arbitration. So it means that you can have an arbitration agreement or an arbitration clause in your agreement at the inception. That's at the inception of your agreement or your contract. You include an arbitration clause or an arbitration agreement. Now, once you do that, the other aspect is where there is no arbitral agreement, there is no arbitration clause, but a dispute arose, and parties feel that it will be in the best interest of the parties to resolve it via arbitration, then they can now agree, they can now prepare an arbitration agreement or an arbitration clause which is separate from their previous agreement. They can as well make reference. They can as well make reference to any other maybe arbitration agreement which they feel they want to adopt, in the course of the agreement. So once that is done, the moment they have an agreement or they do not have an agreement and a dispute arose and parties all agreed that they are going to go by to resolve the dispute by arbitration, that is one of the important things that has been sorted out, But you see, the advantage of having your arbitration agreement or arbitration clause in your agreement at the inception is that the likelihood is once there is a dispute between the parties, the issue of coming together to agree as to how they want that dispute resolved will be very difficult. It is not impossible, but it will be difficult because the parties will be at loggerhead, and then it will be difficult for them to communicate effectively for the purpose of even agreeing on a way forward. So most times it's advisable to have this arbitration agreement. You can have the tripartite, or you have an ADR clause that covers negotiation, mediation, arbitration. If this one fails, you go for this, if negotiation fails, you go for mediation. If mediation fails, you go for arbitration. You can have those things. Now, once this thing is done, you have two avenues where you can do that. If parties in their mediation agreement said, for example, where there is a dispute, we are going to be using Settlement House ADR Training Institute as body, as an institution that administer this thing. That means that once there is a dispute, you can just go to the institute and then initiate the arbitration process. You go there and initiate. But just like Isaac said, where the parties have not specifically stated that a particular institution. Then once a dispute arose, it is now for the parties to now agree as to where they want to resolve their matter, which institution, which arbitral institution they will want to resolve their issue or their matter. You have the multi-door courthouses, you have institutions, you have private ADR organizations, depending on which one, and you have the liberty to choose where you want to. That's where it is not specifically provided for in your initial mediation, arbitration clause or arbitration agreement. So once that is done, now the initiation, depending on whether it is institutional or ad hoc. Where it is institutional, you don't need to struggle. The institution that is administering the arbitration already have their rules and regulations. They already have their scale of charges, their scale of fees. They have their own panel of neutrals, all of those things. They will just bring to you their panel of neutrals and then give you the opportunity of choosing. But where parties, for example, fail to agree as to who. Remember, the current law, AMA 2023, clearly provides that the default number of arbitrators will be 1. Unlike the previous Arbitration and Conciliation Act, which provided that you have 3 arbitrators, except where the parties will want to say, no, we want to just want 1 arbitrator. But a full panel constitute of 1 arbitrator in the AMA 2023 Arbitration and Mediation Act. So if the parties, for example, fail to agree as to the appointment, you can decide to say, okay, if there is a dispute, you include it in your agreement. You want the president or the executive director of Settlement House ADR Training Institute to appoint an arbitrator for you. Once you do that, once there is a dispute, you just notify Settlement House ADR Training Institute and they appoint. But where you do not make such provisions, it means that it is now the party's role and responsibility to appoint a mediator. I'm using your question to be able to give you foundational things that you need to know. If you are with me, if you are all with me, please let me have a thumbs up. A thumbs up if you are with me. So I'm using the opportunity to lay a background and a foundation so that you have an idea what arbitration is and how to even commence it. So once you are able to agree as to, if your agreement covers that you say that particular institution will administer it, then so be it. That institution will now appoint, or based on their guidelines or their rules and regulations, they will guide you on how to appoint. They will provide the experts in that field for you to choose from where necessary. But where parties fail to agree, then there is a provision as provided in the rules of the institution that you should be that the president or the executive director of Settlement House should appoint an arbitrator for you. And once that is provided, then you have no problem. That will be done. You will appoint, and then unlike mediation, arbitration, once you agree that you want to do arbitration, then you must do arbitration. You don't have any option than to say, even if you decide that you are not going to attend the session, once they commence the arbitration and they give you the appropriate notice, that is sufficient. They keep serving you just as in court proceedings. If you decide to come, fine and good. If you don't come, they will continue with the process until they are done and an award is written. Now, once you have started, once you have stated and the arbitrator is appointed, how do you appoint the arbitrator? The person who wants to initiate the process can simply write to the arbitrator. That's if it is ad hoc. But if it is institutional, the institution will now, after appointing the arbitrator, they will write to the arbitrator notifying him that so parties, have a dispute and you have been appointed as the arbitrator. Now, once you are appointed as an arbitrator, that's if it is institutional. If it is ad hoc, the parties will have to agree on which arbitrator they will want to appoint. But you see, just as I said, if there is a dispute, it will be difficult for parties to agree. So what one party, the party initiating the process, will now issue notice of arbitration to the other party. So you just write notice of arbitration, give a brief summary of the dispute, make reference to the agreement, the arbitration agreement or arbitration clause, make reference to it and say, okay, this dispute has arisen. In our agreement, we said that we'll try negotiation, and if it fails, we'll try mediation, and if it fails, we'll go for arbitration. And we have tried a negotiation, it failed. We tried mediation, it fails. Now we are going for arbitration. You state it, in your notice of arbitration, and you propose the arbitrator. You said that you are proposing Nanchang Nangwang as your arbitrator. Nanchang Nangwang is maybe the executive director of Settlement House Area Training Institute. And look at his profile. This is what he does. He has specialty and understanding in arbitration. You propose an appointment, and when you are sending your letter, it's good to usually the notice of arbitration. It's good for you to indicate in the notice of arbitration that, okay, you are expecting a response within 7 days or within 2 weeks. If the other party has issues with the proposed arbitrator, has issues with Nanchang Nangwang as the arbitrator, for example, is going to communicate that objection and then possibly propose whosoever he wants, within the period of 1 week, 7 days, or 14 days. You can state it there. If after this period you did not hear a response from them, it will be deemed that the person has acknowledged or accepted, that's the other party has accepted the appointment of Nanchang Nangwang as the arbitrator. If you are with me to this point, can you give me a thumbs up? Everybody, if you are with me, give me a thumbs up. I can see only one person. Okay, 2, 3, 4, 5, 6, 7, 8. We have about 37. Give me a thumbs up if you are with me and if you can hear me. All right, perfect. So now, once you have issued notice of arbitration, you give a time within which you are expecting a response or a reply. If the person is agreeing to the appointment of the arbitrator and the notice, you will say yes. If you have issues, you say, we have not fulfilled condition A, B, and C, all of those things, he will raise it. But after 2 weeks, if he has not, then the mediator, the arbitrator that is so appointed, needs to issue an acceptance letter, as well as a letter indicating he is non-partisan, or he has no interest in the matter, or he has no connection with the, just like you need to show that you are going to be impartial. You send your acceptance of the appointment together of letter of non-interest in the parties, or non-involvement, or that you did not know, or any of the parties, and all of those things. You are going to be impartial. You are going to send it, accept it, and accompany it with that notification. Once that is done, what you do is to, now the arbitrator will call for a preliminary meeting. Please, can you hear me? Let me hear your voice. Can you hear me? Are you understanding? Am I making sense?
Yes, sir.
Yes, sir.
Yes, sir.
So
Yes, we can hear you.
all right, thank you very much. Now, once the arbitrator accepts the appointment, he's going to call for, is going to issue notice for what? The first preliminary meeting. Now, at that first preliminary meeting, I don't know if any of you have discussed even the content of what should be discussed. That meeting is the first preliminary meeting. Now, you may be asking the parties to come together for you to be able to meet and agree on important issues and matters that govern the arbitration proceedings. Now, what are those things? Now, maybe you do not have the copy of the agreement and the arbitration clause, all documents, all the things that concerns the arbitration. They are supposed to bring it at that first preliminary meeting, and then you are going to be discussing important issues. Now, when you issue notice of arbitration, you are going to come as the arbitrator. You are going to come to that preliminary meeting with a proposed appointment, proposed registrar and secretary. Now, let's say, for example, who is the person who asked this question? Is it again, please?
Ashimi Salvan, sir.
Okay, Ashimi. So now I will say that, okay, upon my appointment, I'm proposing the appointment of Ashimi as the registrar and secretary, or registrar and then another person as the secretary of the tribunal. I'm going to get his profile. I'm going to state it and attach it, possibly if I like, to the notice that I'm sending to them, notice of preliminary meeting. So once the parties have agreed and they converge for the preliminary meeting, then you discuss what happens where one of the party did not show up when he is properly served with the notice. You can decide as the arbitrator and say, okay, let us give him a second chance or a third chance, so that let him show up for the preliminary meeting. But if he did not show up after the third, for example, that's discretionary. Some arbitrators will just go straight ahead once they are sure that they have served the notice for, they will just go ahead and proceed. So, but in case they want to give you benefit of doubt, the other party, they will give him like 2 adjournments or 1 adjournment, and then the next time they will sit down and do the preliminary meeting. Now, the preliminary meeting, you are going to first be presenting, and you even come along with the registrar and say, okay, this is the person I'm proposing. Look at his profile. I feel he is qualified. He's going to help us to administer the administrative aspect of this and secretarial aspect of the arbitration. You state it, so you present it, you present his profile. They will go through it and say, okay, do you agree? Did you accept the appointment of Mr. Ashimi as the registrar and secretary? Party A and B say, yes, we agree, we accept. Say, yes, okay, that's good. We are going to discuss the fee. How much are you going to pay for this arbitral secretary? You discuss it and agree. We are going to pay 10,000 naira or $10,000 as the fee. Now, if you have agreed, you are going to pay 10,000 naira as the fee for the registrar. Now, the fee of the arbitrator has to be discussed. The arbitrator, if it is a single or a panel, it has to be discussed on how payments are going to be made. You are going to discuss it in the arbitral meeting. That's why it's important for the 2 parties to come. If one party refuses to come and then you agree $10,000 you are going to pay, the other party feels that no, this thing is too much. That's why you have the opportunity to come so that you agree. That is if it is ad hoc. If it is institutional arbitration, most times the institutes like Shati will have its own rules and regulations and its scale of fees, which before you initiate the process, you must have paid a certain amount to the institute or to the institutions. That's if it is an arbitral institution. I keep hammering and repeating over and over so that the person who asks it will understand. Arbitral institutions. It could be settlement house. It could be a multi-door court house. It could be Lagos Court of Arbitration. It could be International Court of International Chamber of Commerce. It could be different, ADR organizations, which we have them all around. So those are arbitral institutions. Now, once the preliminary meeting you discuss, then one of the things that when you discuss the fee of the arbitrator, you discuss the fee of the arbitral secretary, and you have agreed on it and how it is going to be paid, then you make provision and agree on where it is going to be paid. Is it an account of the registrar or the secretary that is going to be paid? When is going to be paid? Now, another thing you need to discuss is processes to be filed. Your statement of point of claim and point of defense, that you need to file. The person, the claimant who is making claims, before the arbitration initiates the arbitration, is going to provide his own statement of claim according to lawyers. He will state his reliefs, attach the document and the necessary things he needs to, attach. So also, the point of defense, the other side will also respond to those things. There are situations where you can have a counter claim to the claim of the claimant. In that situation, you also allocate time. So you need to agree on the timing. Starting from today, I have 2 weeks, 3 weeks, or 1 month. I'm going to file my point of claim. Upon serving of the point of claim, the respondent or the other side will say, I'm going to respond to this thing after serving me. I'm going to respond within 2 weeks. So you have 1 month, 2 weeks. Now, will the plaintiff or the applicant or the claimant respond? Or does he have any response? You give like 1 week. Then, is there a counterclaim that the claimant needs to respond to it? You also consider it. But if there is none, the documents, possible documents, and the things that need to be attached, all of those things, you state timings within which these things needs to be done. Now, you need to also consider whether you need an expert witness. Does the case require for you to go? Are you going to require a witness? Which type of hearing will you want to adopt? Do you want to go for document only arbitration, or you want to go for hearing where parties will be asked questions, will be cross-examined? Now remember, when it comes to arbitration, the rules of evidence for lawyers, the Evidence Act does not apply to proceedings under the Arbitration Act, although it looks similar to the court proceedings, but the technicalities and the application of the law and the Evidence Act, the application of the evidence, especially during trials, are not. Before you start raising objection and objection and objection, based on what they say. Okay, these documents are not certified, they are not true certified copies, they are public documents, and the only form that is admissible is this and that. They are not applicable, right? So you decide whether you are going to go for document only arbitration or you are going to go for trial, wherein you are going to call your witness, he adopts his statement, you have a registrar who is going to administer oath, and then the party comes, whether the claimant or a representative, comes before the table, makes his presentation, adopts his processes, and then the other party would cross-examine him, ask him questions. So if you need an expert witness, for example, you are going to agree, yes, because of the technical nature of this thing, it is a medical dispute or a construction dispute, we need a quantity surveyor, we need an estate surveyor, we need an architect, we need a builder, and all of those things. So you have to decide whether you need any of those things. So when you have agreed on all of those issues, then you are going to discuss about the venue. I don't know. You need to also understand the difference between the seat of arbitration and the seat of arbitration and the place of arbitration. Yes, so this one of it is talking about the rules that is applicable, while the other one is talking about the physical venue. The place has to do with physical venue. So you can have a seat of arbitration in Kaduna State, Nigeria, for example, but the physical venue, the place of arbitration can be in London. So when you are sitting in London, the law and the rule that is applicable is the law of Kaduna State, for example. So you need to take note of that. The place of arbitration, the seat of arbitration is very, very important. So you see, before now, most of the arbitrations that we used to have in Nigeria is either they go to London, they go to yes, UK, they go to maybe Singapore, they go to Lagos. If it is within Nigeria, they go to Abuja majorly. Why? Because the law, that's the seat of arbitration. The law in those areas have been advanced and developed, and they are friendly, they are applicable. Why do you choose a good seat of arbitration? Because when it comes to enforcement, or when you need to rush to the court to do something, you want to go to a place where the court is working, not the one that you want to do something, and then they tell you that they have gone on strike. The judge doesn't sit, he has to, you have to take like 1 month or 2 months adjournment and all of. You are looking at the law, the place where arbitration has been thriving, cases and matters have been handled. You have a lot of, laws that govern arbitration. They gave it a very good atmosphere to operate. These are the things that you must take note. They are very, very important when you are deciding where. In Nigeria now, we have a lot of states, advancing and coming up. So instead of going to Abuja or Lagos, they will stay. The seat of the arbitration will be in their own state. For you to carry the money and the resources that is meant for a particular state and go and spend it in another state, and all of those, another country. So those are things that you consider. Now, when you passed the preliminary stage, at the end of the preliminary meeting, timing, venue, applicable rules, you can decide to adopt the rules of any institution. Nigerian Institute of Chartered Arbitrators, the rules of Settlement House, use of Africa Center for Collaborative Dispute Resolution. You can decide to adopt the rules of one multi-door courthouse if you so wish, that will guide your process or your procedure. But if it is an institutional arbitration, that institution already have its own rules and regulations. You decide the seat and you decide the venue in your preliminary meeting, if it is not expressly stated in your arbitration clause or in your arbitration agreement. Now, after the first preliminary meeting, all the things that have been agreed upon, the summary of the proceedings and the agreement, immediately you approve the secretary. The parties approve the appointment of the secretary and the registrar of the tribunal. He commences his work immediately. He records with a recording device. He takes note, because at the end of it, he's going to give you a translated version and a summary of all the processes and the proceedings. That is his work. So he will record and he will write. So the registrar commences his work immediately upon appointment, and at the end of that proceedings, the arbitrator will issue what is called a preliminary order. He's going to issue an order of direction after the preliminary meeting. An order of direction is going to carry the summary of all the things that's agreed and applied upon, and then he will give an order of direction. Party A, file your process within 1 month that you have agreed. Party B, file your response within 2 weeks. This person, yes, so amount of money needs to be paid to the registrar or the tribunal or to the institute's account on or before so time, and the rest of it. If all the things and the issue, including the venue, accommodation, welfare, transport, logistics, all of those have been agreed upon, the arbitrator issues arbitral an order of direction, and the order of direction will state clearly things that needs to be done within what time. Now, some people may decide to adjourn for hearing straight away, but sometimes you can decide to apply for another preliminary meeting, another meeting, just to come and confirm whether all the things that you have agreed upon has been complied with? Has parties filed their processes as agreed? Have they contacted the witness? Have they agreed on all of those things? If the parties have agreed on those things, that would be wonderful. If the parties have made the payments they need to make, the deposit they need to make deposit, and if you confirm everything is okay, right, and it is fine, the arbitrator confirmed that's in the second meeting, then you cannot adjourn the matter for hearing. Now, arbitral proceedings is what I've started telling you from the inception, Mr. Ashimi.
Yes, I'm with you, sir.
From the process of the notice of arbitration till the acceptance, and then the law is that once you issue notice of arbitration, then arbitration has commenced. The arbitration proceedings are those things that you do when you initiate, you commence it, then all these processes and procedures that I'm explaining to you from the beginning to the end, those are the arbitral proceedings. You come, you have done your preliminary meeting, it's part of the proceedings. You come, you do your hearing, it's part of the proceedings, and then at the end of it, award is issued. That is it. So once you are able to adjourn for hearing, the hearing is the same way it is in court. You have the claimant, processes have been filed. If it is a document only, you don't need to go into hearing. You can just allow the arbitrator to look at your processes and the documents you have prepared, and the arbitrator will issue an award. But if it is not, you have to call your witnesses. Your witness will have to come and testify, adopt his processes. He will be sworn in, adopt his processes, he will testify. After he adopts it, the other party will cross-examine and ask him questions. And after that is done, you give party B the chance to present his defense, adopt it, and once it is adopted, the party is being cross-examined, and then he's discharged and he goes. At the end of it, the parties at your preliminary meeting, one of the things you agree is also whether you are going to allow oral arguments, or written argument. After the close of proceedings, are you going to allow parties to address the arbitrator in writing or orally? Parties who agree on those things, so that at the close of evidence, close of the proceedings, parties who address the arbitrator. After they address, then the matter can now be adjourned. If the arbitrator discovers that everything has been done, all condition precedents have been complied with, he would publish his award. Publishing the award simply means he's going to send the award to the parties concerned, and that will bring the arbitration proceedings to the end. So that's briefly how the thing is going to. These things can take as short as possible, and it can take as long as possible. So arbitral institutions are the institutions or organizations that administer the arbitration. The arbitral process, in the essence, is the arbitral proceedings are the step-by-step things that have been carried out in the process of administering the arbitration, from preliminary stage till you get to hearing, till close of evidence, presentation, final addresses, and the rest of it. Those are the proceedings. I hope I've attempted your question, Mr. Ashim.
Yes, sir. Thank you very much for the insightful explanation, sir.
All right, thank you. So,
All right. Thank you so much, Mr. Nyacham, and thank you, Ashimi, for your question. So we have a few other questions. Ines Suma, please, you can go ahead and ask your question. And then there's a question that was sent to me, and that I'll be reading out after she's done asking her question.
Okay,
Miss
good
Suma.
evening, sir. Good evening,
Yeah.
sir. Good evening, everyone. So, sir, you mentioned that you mentioned the institutional arbitration and then ad hoc arbitration. And I have two questions actually. So my first question is, in a situation whereby, since we have the um AMA 2023, and then we also have like institutional rules, is it that the institutional rules are subject to the AMA, or is the AMA only for the multi-door courthouse, and then the institutional rules are just for the settlement houses, or the settlement houses that choose to go with that? So, for example, now, are the settlement house rules or institutional rules, are they subject to the provisions of the AMA? That's my first question. And then my second question is, you mentioned that parties have to, in ad hoc arbitration, parties have to, agree on an arbitrator. So you send the name of the arbitrator to the other party, and then they have to, go through the person's profile, and they're like, no, we don't want this person, we want this person. So in a situation whereby that back and forth keeps on going, like when that back and forth continues, what can be done, or how can parties resolve that, like where each party is still trying to push their own arbitrator and they're not settling on someone? How can they get past that in that kind of situation? Thank you very much.
Okay, please, is there any mentor who wants to attempt the question?
Okay, I think let me add something. Maybe you can come in. When it comes to the question she asked about whether the AMA is for the multi-door court, and since various institutions have their own rules, what are the rules? The rules are like the procedures. Rules are not the governing law. So that's that basic understanding should you should get that basic understanding that the rules are not the governing law. The rules are like procedure. How should we come to settlement house? What should be done? How should the filing be done? How many copies? What number of days should that be done? Those are the procedures that the rules that the settlement house has done. But that does not supersede the governing law. If there is any issue that the parties do not agree on the rules at the settlement house and it has to go to court, the governing law will now be used to settle that issue on the point of law. So you are not going to say that we have chosen our rule and that is all. That is why Nanchan keep mentioning that the seat is very important, because if you choose a seat and their laws are not friendly, it allows for the intervention of the court at any time. It is difficult for you to run a smooth process. So you should have, before you choose a seat of arbitration, if you are doing domestic arbitration, you don't have a choice. It means that it is your local law that governs it. If you are doing arbitration within Nigeria, it is the Nigerian law that governs it. So you cannot run away from the law. You must make sure that the rules that you select complies with the law. So for instance, maybe the AMA has given time for notification and the time for the person to respond. Then the settlement house, maybe AMA gave 30 days. Then settlement house also rules. It gives 10 days. If it goes to court, the court will rule that the settlement the settlement days is below the number of days that the court given. So or the act has given. So they must comply with what the act is saying. It doesn't mean that when the settlement house rule says 10 days, the people should not comply. But in the event that the parties do not agree and they are finding issues with it, that's where the governing law supersede the rules. So the governing laws runs all the centers, both private and government and everything. You all go under the governing law. It's like when you go to the court, we have the Court Act itself, which governs the courts itself. But we have the various rules for each court. For instance, when you come to Ghana, we have constitutional instruments for each court. So we have three categories of courts in Ghana. We have the lower court and the lower then the higher court. So the lower and the higher court, and sometimes regional tribunal, those are not even working. So when they have the lower court has their own rules. The higher court has their own rule. Then when you go to the Supreme Court also has its own rules. So you cannot go to the Supreme Court and use a high court rule. You'll be thrown out. The same way that parties decide to choose a rule that they want to use it to run the arbitration process. It only helps them to know that when I want to start the arbitration or initiate the process, I must first do this. I must first do that. The rules will tell you what to do. So that is what I want to say. Thank you.
All right, thank you.
So I had a second question. I asked the second question.
Okay,
Yes.
can you repeat the second question again?
My second question was because Mr. Nanchang mentioned that when after the notice of arbitration is given, it's now down to the appointment of arbitrator, and in ad hoc arbitration, the party that initiates the arbitration proceedings has to write down the arbitrator that they are recommending for the whole process, and then the other party has to view it, go through the arbitrator's profile, and then when they are done with that, they'll have to agree on whether we want this person. If they don't want that person, they give their own suggestion on who they want as an arbitrator. So my question is, in that situation whereby the parties, like in a situation whereby the parties are going back and forth on who should be their arbitrator or who should be their arbitrator in an ad hoc arbitration, how can they resolve that when they are not coming to an agreement on who should be the arbitrator in the first place?
Okay, so when it comes to ad hoc, mostly the way they draft the arbitration agreement helps the parties to choose the arbitrator that they want to use. Either they want to use a sole arbitrator, or they want to use a three arbitrator, or any number that the parties may agree. But in the event that the parties do not select or agree on all those things and they are having difficulties in selecting a particular arbitrator, that is where the governing law comes in. Or sometimes some of the rules provide for instance, you have chosen a certain rule which says that in the event that the parties fail to agree on an arbitrator within 30 days, the center has the right to choose an arbitrator for them. So if the rule says that, they mean that once the parties are not agreeing on the arbitrator, the rule will be used to select the arbitrator. Then with the ad hoc that you were talking about, that when you write, yes, it depends on the clauses. Sometimes the clause says that each party will select an arbitrator, and the two appointed arbitrators will select the third person. So it means that you, the party initiating the arbitration process, must indicate your choice, your arbitrator that you have appointed. So you must make it known to the other parties. If they have any issues bordering on maybe conflict of interest or anything, they can raise it, and then you see what can be done about those things. But once you are initiating the process, depending on the rules, you must necessarily select your appointed arbitrator. Then the other party will also reply. In their response, they will also bring to your notice their appointed arbitrator, and they may also call for maybe a preliminary meeting, or your initiation, maybe your notice, you call for a preliminary meeting to be held between the two before the notification to the arbitrator. Sometimes the parties may initiate the process and inform the other party without even notifying the arbitrator that they have appointed or put their name inside their notification. They might not have even notify him until maybe the parties are ready. Then they can agree on the timelines to notify the arbitrator, and the arbitrator will now, once the arbitrators are notified, it means that their work has begun. So the arbitrators will now also write to the party that has appointed them whether or not they are available for the process or they are not. I've seen instances whereby arbitrators have declined the appointment, maybe based on the fact that they have other appointment or maybe health issues or conflict of interest, they can also decline the appointment. So all those things happen. So it is not hard and fast way. It is procedural, and you must follow the step-by-step process. So that is why parties must create a pathway that they want to use to resolve their conflict, whether through the arbitration agreement that the prior agreement that they make in their contract, or a separate agreement, or the submission agreement that they want to do. They must be clear on the processes that they want to undertake in order to select the arbitrator and what should be done next. So by so doing, it brings a clear pathways for the parties to conduct the arbitration. In the event that they don't have that clear pathways, that is why you have a governing law to come in to assist. Thank you.
Thank you very much, Mr. Isaac. Today that you wore a glass, I was like, well, soup. All right, thank you very much for that wonderful contribution. Mmesoma, if I'm correct. See, if you look at AMA, ADR generally is party driven. And so even the rules and the laws, right, are subject to the rules and the laws are subject to what the parties provide. So if, for example, the parties have agreed, if the law, that's AMA, says that notice should be given within 30 days, but the parties decides to agree that in their arbitration agreement that the notice that should be given should be within 14 days, what the parties agree prevails. But if it has to do with conflict between an arbitral institution rules, if it has to do with a conflict between the arbitration, the Arbitration and Mediation Act and the rule of any arbitral institution, then the provision of AMA prevails. Mmesoma, Abi? Do you understand?
Mesoma. Yes, I
Mmesoma.
understand.
Yes, so it is parties that decide. If party says instead of 30 days, we want to do it 5, in fact, that is what is called accelerated arbitration. That's emergency arbitration, that you have to do it as quick as possible and issue a interlocutory award. How do they used to call it? Yes, you need to issue an award pending the determination of the whole. Let's say there is a perishable goods that is on transit, and there may be the vehicle spoiled, or so there is an issue on the way. What will you do? You go for an emergency arbitration where you get a direction, where the arbitrator can decide and give a direction as to what should be done pending the determination of the entire suit. So everything is anchored on the parties. The parties are the Lord. In ADR, they are the one who decide the arbitrators, they are the one who choose the arbitrators, they are the one who pay the arbitrators, they are the one who do everything. Remember, one thing I failed to mention is the fact that parties are the ones who pay the arbitrator, and then they share the fee equally. So if it is 10 naira, for example, that 10 naira will be shared between party A and party B. So each party pays for 5 naira. So that's how it is done. Thank you very much, Ms. Soma. Yes.
Thank you, sir.
Mr. Dennis, you said you had some other questions?
Yes, sir. Yes, sir. There was a question from the group presenter. She said she was having difficulties indicating by raise of hand. So our question is, in a non-arbitrable dispute like murder, if parties come to a settlement instead of prosecution, can't that still be said to be negotiation, which is under ADR?
Is our question under arbitration or under ADR?
Well,
Can she
under
ask the question directly?
All right, group presenter, please, you can unmute and ask your question directly.
Okay, good evening, sir. The question is under ADR. I was just thinking that if
Can you put on your camera? Is it Master?
yes, but it's another Mr. It's not the same person.
Yes, go ahead.
Okay, sir. So under non-arbitrable disputes, we have criminal matters, which is murder. But I think there are some cases where, like this Dangote case, where he hit Fina's sister, and there were a lot of complications to it. If Fina now decides not to sue, Dangote settles her for the all she has gone through. Can that not still be said to be somehow, I don't know?
Don't know the question you're asking, or what is it that you don't know? Are you talking about settlement in criminal cases?
Yes, yes.
Now you see, in criminal cases, the offense that is committed is against the state as against an individual. For example, you assaulted somebody or you hit somebody and the person breaks his leg or the person dies. Now, the family may decide to say, oh, we are Christians, we are Muslims, we are this and that, and then we are forgiven. But the fact that the parties are forgiven does not mean that the state can say, oh, no, okay, since they are forgiven, no problem, let them go. No. Whether they are forgiving the person who committed the offense or not, the state can still prosecute because the offense itself is committed against the state. But we said that in arbitration, there are matters that are not arbitrable. And one of those is criminal issues and matters that the parties do not have absolute control. Things that are contracts, for example, that are illegal are at first sight ab initio. Contracts that are against public policies. You ask somebody to supply maybe AK-47 or cocaine, for you, and then after paying, the person did not provide those things for you, and you feel that no, in our agreement there is provision for arbitration, so we'll go for arbitration. No, those things are against public policies, they are illegal, and if it is criminal offenses, they are not arbitrable. But are we saying that, for example, where there is an offense and the parties decide that they will sort themselves out? For example, recently I had some clients, that they went to their place to do an execution, and then one thing lead to the other. The bailiffs wanted to pick the property belonging to the company, but those property that they are making use for in the office, the parties, the clients are saying that it is not the company's property, it is their personal property. So they said no, they are not going to release it. So that's how they keep dragging and dragging and dragging, one thing leading to another. And eventually the bailiffs were assaulted in court and all of those things. They went back to the court said, go and arrest everybody and bring in, and they filed a case possibly for criminal conspiracy, criminal trespass, preventing or be stopping public officers from carrying out their duties and all of those kind of things. These are criminal in nature. So they refer the matter to the police for investigation. After investigation, they are supposed to file an FIR. So against the clients. So but we discussed and said, okay, these people say, okay, if okay, since you've assaulted me, you did like this, my phone is this and that, okay, I don't have problem. I can decide that to withdraw my charge or my complaint against you, if you will pay me maybe 10,000 naira or 10 naira, for me as compensation for the assault and the wounds and the pain and all of those things and the discomfort of staying without my phone, and the things I missed. So parties decided to say, okay, let us discuss, and they reached an amicable settlement, and they went to the court and apologized, and then the court parties have settled. They have officially written to the police to say that, okay, there is no need to continue this investigation or continue the process or the prosecution because parties have resolved their matter. These are issues that are not capital offenses, they are bailable offenses. But when you commit an offense of murder or you commit rape, which are capital offenses, they are by nature, ordinarily they are not bailable unless you are able to establish special circumstances. So in those cases, there will be no issue of settlement there. So, and then even if there is settlement, it cannot come under arbitration. Arbitration is a procedure where a third party neutral is appointed by the parties and given the power to hear their disputes, go through their processes, and then deliver an award in the form of judgment, which is in court. In court, they call it judgment. The arbitrator gives an award, and that award is binding and enforceable against the parties. So that's the procedure. So the issue of whether if you settle, you cannot bring a settlement in criminal matter and say, let there be an award to that effect. No, it can only be done during negotiation or mediation. But this one, arbitration, has to do with the arbitrator giving an award. So that is what it entails. So strictly criminal matters are outside the bounds of arbitration. I hope I attempted your question. Please, Mr. Dennis, I think there are some questions on the chat box.
All right, thank you, Mr. Nyacham. So to answer okay. Okay, I think it's a similar question that the person who asked this is asking. She's saying that, please, sir, can you use Fina's sister case to explain? If Fina and her family decides not to report the case to the police, will the issue of manslaughter arise? If no, Dangote Group will definitely settle her and her family. What do you call this? Because it is not all cases in Nigeria which are not arbitrable that are settled by litigation.
You see, they say police is your friend. Abi, if there is an issue or a crime around your area, you call the police, you inform them. But if you do not inform the police and the police do not know about it, somebody is dead, the parties have accepted their fate, and they have gone to bury, for example, you take your person to the hospital and you try to save the person and the person could not be saved and the person died in the hospital. You just carry the corpse to the mortuary, keep it in the mortuary and set a date for burial, and then afterward you go and bury. Now, police will not be, but if the death came about as a result of a criminal activity, maybe armed robbery, maybe there is an accident, you hit somebody and the person dies, it could be accidental, it's not intentional, but it's also murder, or and all of those things. So if it is a situation like that, the police are not aware, parties did not report it, and they have decided to go on and then they get settled, that since it has not come to the knowledge of the police, there is nothing the police will do about it. Nobody is reporting any crime, nobody is reporting. But if they get to know that there is any criminal activity that happens, they can decide to investigate the matter, and if they're able to establish evidence, they could prosecute whosoever they found as a suspect in that case. But generally, there is what is called victim offender mediation, and there is what is called restorative justice. These are concepts that are actually used in the criminal justice system. So you stole my property, you did an robbery, you stole something, and then you are caught and sent to prison, and then you are trying to see how you can bring the person who is a victim and the perpetrator, trying to do a kind of settlement and mediation, so that this person will not feel okay, these people are just moving around stealing, killing and cutting away people's properties and nothing is being done. This one now will, after serving a sentence in prison, and then to come back and get integrated into the society becomes very difficult, because everybody say, look at this thief, this is armed robber, and all of those. So you have community kind of mediation with victims and offenders, so that you see that this person may have repented and is very sorry for what he has done, but the victim may carry that pain and that anger against that person for life. Even to forgive will be very difficult. But by the time you interact in a safe environment and you see how remorseful, maybe this thing happened, but it was an accident, you see how remorseful, you see that there will be a kind of reconciliation. Restorative justice, on the other side, is just a way of trying to restore the other person who is a victim to a position, as much as the law could assist and all of those kind of things. So these are things that are provided within the criminal justice administration to see that there is a way things can be done. For example, you have plea bargaining in criminal justice. Somebody is saying that, okay, did you commit the offense? Say, yes, I commit the offense. I will admit and I will return the part of what I have stolen, and if it's still available, I will return either all or part of it in exchange for a lighter sentence. Or, okay, you are convicted, but you are sentenced to community service for 10 weeks, for 100 weeks, or for 1 year. You have to be reporting. You have to be reporting every. You have to be reporting every. You have to be reporting every week, to the probate of the person that is in charge of that punishment. So these are things that you must you consider. Those are forms of negotiations that happen in the criminal justice system, and they may not necessarily be arbitration. It cannot be arbitration, but there are for some form of settlements that happen in the criminal administration system, which I've given you some of the examples. Is that okay?
All right, thank you so much, Mr. Nyacham. Do we still have any questions? I think we have gone a little bit far spent our time, but we can take one more question. If we have one more question, we can still take one more before we call it a day.
Okay, in the
Do we have
meantime, Mr. Adams, is Mr. Adams here still with us?
Yes, I'm still here.
Okay, please, will you like to give us some insight on career opportunities in arbitration?
Career opportunities in arbitration. You have mentioned some of them. One of them is being a registrar in arbitral proceedings. The other is being the secretary to an arbitral proceedings. The third, of course, is being the arbitrator. With that, you have to go through some courses and training. Another, you can be a repertoire. You can yes, they have a secretary, but at least you can still compile records. You can still person can compile records. You compile records basically. Uh, in arbitration, I mean there will be need for personal assistance, for the arbitrators themselves, and these are basic ladders that one can follow, at least not the arbitrator themselves. And also, with time, yes, I know that arbitration is confidential, but I mean, someone can place the trail by, reporting not necessarily the parties themselves, but at least if you have the consent of parties, it can be reported, even though it's not the parties themselves. I believe those can are career path in arbitration, and also, coming together in partnership or collaborating with existing arbitration institutions too. It's also, in a way, a career path. So one just has to be innovative in ADR, basically, coming up with ideas and innovations to assist arbitrators. Thank you.
Thank you very much. Now, in addition to what Mr. Adams have said, we have sport arbitration. You have construction dispute arbitration. You have medical dispute arbitration. You have labor arbitration. And some of these things have statutory flavors that they said, okay, before this is done, you have to compose a tribunal, an arbitration tribunal, to be able to handle this and this and this. Medically, labor law, you see them there. Sports, construction dispute arbitration. You have maritime arbitration. You have a lot. These are different fields and careers that you can actually take. You can actually take and specialize in, depending on what you want. IP, intellectual property arbitration, we have things like that. We have all of those things. These are all career opportunities. Which area do you want to specialize? That's what you should be asking yourself. Which area do you want to specialize? Which area do you have flair for? Which area do you have understanding, or you love, and you have subject matter expertise in that field? Is it construction dispute? Are you a quantity surveyor? Are you a builder? Which aspect? Are you a medical doctor? Will you want to go into medical arbitration? When it has to do with some processes and procedures, they said you have to form an arbitration tribunal, to be able to dispose of issues and matters in that field. So the career opportunities are wide. You can be a researcher. You can be a trainer. Like now, I teach arbitration, I teach mediation with Settlement House ADR Training Institute. I teach in multi-door courthouses. I teach ADR with Institute of ADR Registrars. I'm a faculty member of Nigeria Institute of Chartered Arbitrators, where we teach people who want to become arbitrators. So that is also a career path. You can be a publisher. You can publish. You can write books. and journals in the area of arbitration. You can write articles. You can be a researcher. You can also teach arbitration in the university, in schools where they have, aside from law, I know that estate surveyors, accountants, quantity surveyors, builders, architects, all these people we are talking about, they take arbitration courses one way or the other in the course of their training. So you can teach in that level, you can teach professionally. It's a field. You can be rented as a judge. You'll be able to appraise people's issues and matters and then give your opinion as to the fact. You give your opinion as to you give a form of judgment that will guide the person who wants to take up action or issues to know, is this thing okay? Should I spend money and resources? This could be the outcome of the matter. What happens? Do you get? So these are some of the areas and fields and places where you can actually go and specialize. Pick an area. Sports. Sport is one of the lucrative aspects of arbitration. You have mediation and arbitration in that area. Intellectual property, just to mention it, right? So construction, I've mentioned it. Medical aspects, arbitration, you have it. We have a lot, many more. Mr. Isaac, will you want to add? I can see Nadia Jamal.
I think
Nadia,
you have said a lot in the field, so I think you have mentioned majority of them come as they were mentioned, whether represents registrar of a dispute solution center, getting in some centers they call them administrative secretary. So depending on the environment that you find yourself, you can be administrative secretary for arbitration tribunal, and also be when it comes to institutions that enroll arbitrators on their platform. So depending on their guidelines for enrollment, you can also be a neutral with such institutions. Talking of ACID, ICC, there are a lot of Singapore Arbitration Center and all that. So depending on their structure and how you can become a member, WIPO is there, World Intellectual Property Organization. They also have training and other things that you can look at. You can become a neutral under them. So there are a lot. And like Nanchan mentioned, sports arbitration is coming up, and it has been there. But our local level, we don't really have it much. So we have to make it popular at the local level, and we can specialize in those areas as well. And now we are having a lot of like AI, IT issues and other things. There are new fields that you can also specialize in those fields. So based on your background, you can also specialize in certain areas that you can offer arbitration services in that respect to the people. It's a matter of start with what you know, let everyone know what you have learned, and build on that. Based on that, people will not just look for you, people will be recommending you. They will say that, oh, I know this person is good in this area, in that area. And that is how you launch yourself into the practice. There is no hard and fast way, just relax, step by step, learn, keep learning and unlearn and build more capacities and offer your services to the people, and gradually you become known and you can do a greater exploit. Thank you, Nanchan.
thank you very much, Mr. Isaac, for that. So when you are looking at arbitration, you look at different aspects of the things. You can carve a niche for yourself if you have specialty in a particular field. And we encourage you. We said, please try and get yourself certified. This one is a mentorship. We're available to answer your questions. If you want to get specialized and skilled knowledge, please enroll. Do mediation skills training, do arbitration certification program so that you can get certified. The field is wide. Create a niche for yourself in a particular field so that in your environment, when they are asking for somebody who is into sport arbitration or sport mediation, your name will be mentioned in that field. That's how to carve a niche for yourself in your environment, in your school, if you are still a student, in your jurisdiction where you practice. Let people get to know you as an ADR person, as a mediator and arbitrator. Take advantage, volunteer where necessary, attend trainings, attend webinars to encourage yourselves. If you look at, there are both free and paid trainings in ADR. Attend conferences where possible. There is a conference for East Africa arbitrators. East Africa arbitration. East Africa arbitration that is coming up and is going to be in Nigeria this time around in October. They have made it a subsidized conference from, I think, 24th to 26th or so. And it's going to be 25th and 26th. And it's going to be an interesting moment for you to interact with fellow like-minded, both young, old professionals in the field, of arbitration. So if you're available and you can afford it, please go on ahead to register. I think the slashed fee is about 175. Is it 175 or 75,000 or so? I think I will share the flyer for you on your platform. So these are some of the networking events where you get to meet people of like minds, and then you can ask them some questions and say, okay, you are trying to find out about this and that, which area, which field. You may even meet somebody who will encourage you and empower you to say, so this thing is happening. It is a kind of motivation, and you'll be very glad that you did. So if you're available, okay, it's 100 and can you see that? Can you see it? Can you confirm if you can see it?
Yes, sir, we can see it, sir.
Yes, I can see, sir.
Yes, so this is East Africa Arbitration Conference that is coming up. If you can go for conferences like this. You get to network with people from different countries, young, old, and then you get connection, you get contact, so that's how you build your network, you build your connections. Where there is a webinar, there is something, that's how you get to know people in the area where you want to specialize. That's how you do it. So take advantage of it. If you are interested, you can send me a message, and then we can make arrangement on how you can get to register where necessary. It's very, very important. Meanwhile, we have also told you that we have Settlement House Idea Training Institute in collaboration with the Kaduna State Multi-Door Court House is having a certification training in mediation. We said that people who have taken this training will be qualified to apply for that particular training, and we'll be happy to see you all there. We'll be happy to see you. If you are available and you can afford it, the training fee is 300,000, but we have subsidized it, especially for people like you, it's 130,000. You can come physically to Kaduna to attend, or you can attend the training virtually. And people in this group who are interested, we can make an arrangement for you in case you cannot afford the early bird, which is going to be closing on the 30th, 20th of this month, is 130,000. If you are interested and you have that amount of money, please reach out to me or indicate on the chat group. Reach out to me, actually, send me a message. I'm on the group, and you register. But if for any reason you don't have the complete amount but you want to pay in installment, also let me know, and then take advantage of some of these things. ADR trainings are actually expensive, and that's why I expect that you are going to take advantage of this free mediation ADR program, which covers both mediation and arbitration. At least you have a general idea. You will not be a novice, in that area. You have general idea of what it entails. But this is a certification training. So if you are interested, please take advantage of it. Begin to build your career, even while as a student, as a young practitioner. Please build your career in this field, and it will be very, very. Having said so, I think we do not have any further questions, do we?
No, sir.
Do we
Yes,
have?
sir. So I want to ask a question, please.
Go
Oh,
ahead.
okay, please go.
Sir, actually, it's not within the scope of what we treated today, but then I was reading an arbitration fact and I saw exceed and then exceed additional facility rules. So I want to know the difference between the exceed and the exceed additional facility rules. Thank you.
Mr. Isaac, this is for you.
Okay. You said you saw ACID. Yes. So the ACID is one of the organization under World Bank which deals with investor state disputes. So when it comes to investor state dispute, they are normally submitted to centers for them to adjudicate. They do mediation, they also do arbitration. So when you see ACID, other facility or service rule, it means that when you go there and you need other services which may not be part of the actual processes, then there are also rules guiding that. That's why I'm saying that when it comes to arbitration, mediation, and everything, it's a structured process. So organizations dealing in that offer you. So they may say that if you are using our facility for 3 hours, it is free. If you are using our facility for more than 3 hours, then the rules say that you must pay this fee. So those are the differences. So it is not a different thing. It is within the same organization, but depending on the services that you want, and the governing policies that runs through those services that they may give you. Thank you. I hope I've answered your question.
Okay, so
Yes,
in
sir.
addition, ICSID is International Center for Settlement of Investment Disputes. So, there are no common type of disputes, and mainly the investment most times is between state and state, like Nigeria and another country. You have nationals of another country coming to invest in another country. All of those things are provided, but these are advanced training in arbitration. So when you start, maybe you do an associate training under settlement house, then maybe you are coming for membership or fellowship. You are going to be taught that aspect and what the rules of different ADR organizations, especially international ADR organizations. Is that okay?
Yes, sir. Thank you so much.
All right. Mr. Dennis, in the absence of anything, do we have any other thing?
No, sir. We don't have any other thing. So before we go, I just want to say a big thank you to our mentors and to the mentees that waited up to this time. We have come to the end of today's session. Please let's not forget to fill our attendance and share what we have learned. Please tag JIIPCC in your post, tag Settlement House ADR Training Institutes in your posts, right? So that people can be aware that these are the institutions that are partnering together to bring to you this mentorship. So good night, everyone. Please enjoy the rest of your evening. Bye-bye.
You add, you tag the mentors. Tag your mentors.
Yes, please tag your mentors also. Thank you.
Thank you.